Hi, everybody. Welcome. I'm Hope from Valley Venture Mentors. We're really excited today to have Rick Kosakowski here for a very informative workshop on trademarks. Rick Kosakowski is an intellectual property attorney with an electrical engineering degree and extensive law firm and corporate in-house experience working with clients of all sizes, including individual entrepreneurs, startups, and small companies. Rick advises clients on various aspects of IP law, including patents, trademarks, copyrights, and trade secrets, and related business law issues. He also advises clients on technology aspects of their inventions, including product design and development. He is a mentor with both BVM and E4All in Holyoke. So thank you so much, Rick. I'll turn it over to you. If you have any questions, if any of the participants have any questions, you can feel free to put them in the chat or just feel free to raise your hand or come off mute throughout the presentation.
All right, good afternoon. Thank you to Tom and Rick for signing up for this workshop. Topic of this workshop today is going to be trademarks and protecting your brands. Since I am an attorney, I have to go through the formalities and just give the standard disclaimer that any information that I present today in this workshop is given for general informational purposes only and is not intended to be, nor should it be considered as legal advice or counsel. Also, no attorney-client or confidential relationship is formed by way of this workshop presentation. And if you do have specific legal questions regarding a situation that you're encountering, I would suggest you seek legal advice from competent counsel. All right, now that I got those formalities out of the way, let's talk about trademarks. Let's start by discussing what are they. Trademarks, it's a component of intellectual property law, which is an umbrella term that we hear all the time. And the four components are, besides trademarks, they're patents, copyrights, and trade secrets. So because trademarks are part of IP law, as you're going to see in this workshop, trademarks afford legal protections to the users of those trademarks. So what is a trademark? It's a word, and this is basically the statutory definition from US federal law. A trademark is a word, a phrase, symbol, or device, or any combination thereof that identifies and distinguishes the source of goods or services of one party from those of another or other parties. So when you think of a device, it's not really like your car keys or your coffee cup or something. It instead it refers to various attributes or features of goods, such as colors, sounds, or scents or smells. And also a component or part of trademarks are, and we're going to talk about this more in a little bit, is trade dress, which is kind of a type of trademark, and it relates specifically to either the configuration of a product or the configuration of the product's packaging. So it really refers to shapes of the product or its packaging or other features such as colors. And also, sometimes we hear the term mark. People talk about, I've registered a mark or something. So when you hear that elsewhere, or you hear it from me today, when I say mark, it means either trademark or service mark. And trademark includes a service mark. So a service mark is a subset of trademarks, but not the reverse. So trademark is a broader term than the term service mark. Service mark is used to denote services provided by a provider, such as a restaurant or whatever, whereas a trademark refers to goods or products, but it also can refer to services as well. So what are trademarks used for? In general, they're used to identify the source of goods or services. They're used to distinguish between different sources of similar goods or services. They help to protect brands. They communicate brand information to the public, and they enhance public awareness of brands. So again, those are general statements. I'll get into more specifics throughout this workshop. What do they protect? Well, they protect brands. And a brand is the public's perception about the quality or characteristics or other features of a product or service. In other words, it's the image of that product or service. How does the public feel about a certain product or service? So trademarks, they also protect the investment in time and money by the brand owners in developing their brands. So a business owner selects a brand and the trademarks to protect it, but those brands take time to develop in value. So the trademarks help to protect the investment in time and money to develop the brands. They also protect something called the brand equity of products or services. And the brand equity is there are these intangible features of a product, the quality, the goodness of the services, whatever, that really cause the public consumers to pay a premium for the products or services that come or that are provided by that brand. For example, people pay a lot of money for a watch made by, Breitling or Vacheron Constantin or someone like that. They're willing to pay a premium because of the quality and other features of it. Also, trademarks protect a concept called a goodwill, which pertains to a business, which the business builds up over time, over the course of conducting its business. So goodwill is actually is something that can be measured using accounting practices, and it usually arises when a company is purchased by another company. So how much is the buyer willing to pay for the seller? Well, they value the hard assets of the company, but then the buyer is also willing to pay a premium above the hard asset price for the company, and it's usually because of the goodwill that the business has built up over time. So another main area that trademarks protect is they protect the consuming public from a likelihood of confusion between different providers of similar goods or services in the relevant marketplace. So likelihood of confusion, I put it in quotes because it's a term of art in trademark law. And it's really a measure of when infringement of a trademark arises. And so it's a concept that has a lot of importance, and you have to keep it in mind when you're selecting trademarks and also when you're trying to decide if someone's infringing your trademark. So on the bottom tagline there, I said it's not actual confusion because by then it may be too late to prevent harm to the owner if the law requires the owner of a trademark to wait until there's actual confusion in a marketplace between its marks and that of the infringer. And then to receive legal protections, the marks must be dissimilar for the same goods or services. So if I have let's say I provide coffee, I'm a coffee roaster, and there's another coffee roaster across town, we have to pick dissimilar marks for those same goods, coffee. So it's a basic premise, and we'll see how it plays out later on. Okay, on the next slide here, it says, we see lots of ads every day. We're seeing more and more of them. You just do some internet searching for articles. We saw that back in 2007, it was estimated that everybody sees approximately 5,000 ads each day, and these ads are loaded with trademark and brand information. But now it's estimated in 2020 that each person sees about 10,000 ads per day. So we're literally getting bombarded with information and advertisements for goods and services. And digital marketing, I think, is largely responsible for this big increase. As a result, it's getting a lot more difficult to differentiate one's products or services from those of another. So one solution is pick trademarks that stand out and that are memorable. So here's a recent example to show how valuable trademarks can be. I'm a fan of hot sauce. I like Cholula. I also like Frank's. But Cholula, which is about a 100-year-old company in Mexico, but has only been selling their hot sauces in the United States for about 32 years. They were recently purchased a couple of weeks ago for $800 million in cash. The entire company, Cholula company, was purchased. It was purchased by McCormick, which is the company that makes herbs and spices, condiments like French's mustard, seasonings, flavorings, etc. Everyone has something of a McCormick product in their kitchen, I'm sure. But Cholula's annual sales are only $96 million a year. So where's the value that justified McCormick wanting to pay $800 million for the company? Well, part of it is the recipe for Cholula is a trade secret. Cholula has been able to keep that recipe secret. In other words, no one has been able to successfully reverse engineer the formula exactly to duplicate it. But the ingredients are common. I mean, we're talking about hot peppers, vinegar, some spices. So there was some value to the sale price there. But I think the real value came with the goodwill of the company. Remember, I said it's measured by the overall value greater than the fixed assets. Also, the brand equity of the products, the premium price that the public pays. And when I saw the news brief, how McCormick was going to buy the company, I think it was a couple days before Thanksgiving, I went on the Stop and Shop website, and they sell Cholula hot sauce for 80 cents an ounce, is what it works out to be. But Frank's, which is also a well-known brand, and ironically, Frank's is owned by McCormick as well. McCormick bought the company that makes Frank's 3 years ago. Frank's hot sauce sells for only 30 cents an ounce. So Cholula, people are willing to pay nearly 3 times as much per ounce of the product as they are for Frank's. So that's where the brand equity comes in for the value. And also the trademarks. Remember, I said earlier, the trademarks help protect the goodwill and the goodwill of the business and the brand equity of the products. So Cholula, its brand is very recognizable due to its products. They even have, besides the word marks, they even have trademark registrations for the shape of the bottle, the shape of the cap, and the label designs. And the shape of the bottle and the shape of the cap are what I referred to earlier as trade dress. And I'm going to get into that in a little more detail shortly. So those registrations help drive up the sale price as well. But McCormick, they believe that, they have very large marketing and distribution resources that they can boost the annual sales of Cholula now that they have the Cholula brand under their roof. And hot sauce sales are booming right now. It's estimated that total hot sauce sales in the United States, just the United States in 2020 is going to be almost $1 billion, which puts it just underneath ketchup in the United States. And that represents a 40% growth total of the sale of hot sauces in the United States since 2015. And also because of COVID, a lot more people are staying home and cooking instead of eating out. So McCormick sales in general of their products have increased this year as well. So McCormick is betting that its resources can help grow the Cholula brand now that it's under its roof. All right, so let's get into some traditional and non-traditional trademarks. So, you know, we all know trademarks as they're either words or phrases such as slogans, or they're designs or logos, or a combination of both. So for people located here in the Springfield area, I'm sure you've probably seen the commercials for Yankee Home Improvement. They keep mentioning their tagline, never cattywampus. So I think I first saw that commercial about 2-3 years ago. I didn't know what cattywampus meant, so I looked it up in a dictionary, and it means something's crooked. It's not level. So their slogan is when they do building work, you know, new homes or home remodeling, kitchens, bathrooms, whatever, all their work is on the line, on the level, never cattywampus. So they actually filed for a United States federal trademark registration last year, and they were issued a registration earlier this year by the U.S. Patent and Trademark Office for the 2-word slogan, never cattywampus. And an example of a logo is what's called the bean seal design, and that's the circle that's not quite complete with the coffee bean in it. And that's by the good folks at Monsoon Roastery in Springfield on Albany Street. I know because I'm their attorney. I represented them. I filed for earlier this year an application to register this logo, and we got a registration issue a couple of months ago. So, and then here's a typical example of a combination word and design mark. The word Amazon together with the smiley underscore there. So let's talk about some non-traditional trademarks. There can be colors, there can be sounds, scents or smells or shapes, in other words, trade dress. So all these examples here, these are actual United States federal trademark registrations. Post-it notes yellow, the UPS brown truck owns Corning pink fiberglass or the Tiffany blue box. The NBC 3-tone chimes, ESPN da-da-da, Sports Center, Darth Vader breathing even, and Homer Simpson dope. Play-Doh scent, this one I wasn't sure of. I saw Verizon stores. I guess I haven't been in a Verizon store lately, but they were able to register a flowery musk scent when you walk into their stores. Then this last one here, it's a company called Oh So Easy. It's a plumeria blossom scented embroidery thread. And that actually was the subject matter of the very first registration, US federal trademark registration that issued about 1990. And some example shapes for products, the Frito-Lay bowl-shaped chips, Hershey Kiss shape, and the goldfish cracker fish shape. And then for packaging, we're all familiar with the Coca-Cola bottle shape, and the IHOP restaurant shape is also a registered trademark. So let's talk a little more detail about trade dress. And trade dress comes into play when products speak for themselves as a source identifier in the marketplace. In other words, there are certain features about the product itself or about the packaging of the product that consumers come to recognize as it being associated with a certain source of goods or services. In other words, the product or packaging has a certain look and feel to it. There are distinct features that are memorable and stick in the minds of customers. And it's even for retail establishments. Like I said, IHOP, I believe Taco Bell has some registrations for its restaurants. However, trade dress is difficult to achieve legal protection. especially for products. For example, the design features must be non-functional. You can't claim functional features as also being part of the overall trade dress of a product or its packaging. So how do you determine if some design feature is functional or non-functional? Well, you ask the basic question, is there more than one way to perform that function? So here's an example. The packaging of a Reese's peanut butter cup. That packaging serves the function of preserving the actual peanut butter cup. So that's the functional nature of the packaging. But Hershey Foods, which owns Reese's, they chose certain colors for the packaging, and they were able to register that color scheme as a trademark for the packaging. Why? Because they could have picked, there's probably an infinite variety of different color schemes that they could have put together and chosen for the packaging, but the one they selected sticks out and it's memorable. When you see a Reese's peanut butter cup, or when you see that package, that's a Reese's peanut butter cup. So it's memorable, it sticks in the minds of consumers. So again, I said it's trade dress applies to both product design and product packaging design. So the US Supreme Court has given opinions over the years regarding trademarks, and specifically with respect to trade dress for product design and trade dress for product packaging design. So the Supreme Court has said that for product design, any design that the brand owner comes up with, that product design can never be inherently distinct. In other words, right from its adoption, it cannot be inherently distinct. Therefore, it cannot function as a trademark right from the start. Instead, it has to achieve what is called secondary meaning. So the Reese's peanut butter, we're talking about the packaging there. So the Supreme Court has also said that for product packaging design, that may be inherently distinct right from the get-go. So for an example of Reese's peanut butter cups, they were able to get a trademark registration with the accompanying rights in the packaging for those colors for the packaging, because they chose a unique combination of colors that were deemed to be inherently distinct. So let's talk about another aspect of trade dress, and that's advertising. I'm sure we've all seen ads on television for products that tell us to look for certain features. Look for the blue and yellow stripes. I just saw a commercial a couple days ago for these certain creosote logs for your fireplace. And the voice on the commercial said, look for a picture of, or a caricature of a chimney sweep on the packaging. So that's what's called look for advertising. It tells the public to look for certain non-functional product features or packaging features to help identify the brand. So that can be color, shapes, other things. It's important to note that when you're doing look for advertising for your brands and your products, you shouldn't tell the public to look for functional features or features of your product or packaging that are patented. Because again, trademarks really cover non-functional features of products, not functional. And also, if you're trying to get a patent on something, a utility patent, you're trying to get a patent on some functional aspect of your product. So if you tell the public to look for functional or patented features, you're really defeating the entire purpose of this look for advertising with respect to your products. So why do companies do this? Well, they want to help create the required level of customer recognition of these product features with their brands. In other words, they're trying to achieve secondary meaning of these product or packaging features. And if you're trying to register, let's say, the packaging for, Reese's peanut butter cups or the Coca-Cola bottle shape or whatever, when you file an application with the Patent and Trademark Office, it's likely it's going to get rejected. The examiner there is going to say there's no distinction, there's no distinctiveness with this packaging or product design. So you may have to provide evidence to the Patent Office that you've been doing look for advertising, let's say, for the last 5 years. You've been doing it constantly, you've done a lot of it. And also, if you want to sue somebody for infringing your trademark rights, be they federal common law trademark rights or federal registration trademark rights, you may have to go into court and say that, I've been using, I as the product owner and marketer have been using this look for advertising for 8 years, 10 years, whatever. Because the entity that you're going to sue for trademark infringement is going to try to say that you don't have valid trademark rights in that product design or the packaging design because there's no secondary meaning or there's no inherent distinctiveness, and in part because you, as the product developer and marketer, you failed to do look for advertising. So, excuse me. So let's turn to what are the legal rights that are given to trademark rights. Well, there's two types of federal rights. We'll start with common law rights. And those common law rights under federal law, they begin when one starts to use the mark on goods or services that are placed in interstate commerce. Now, the federal government only has the ability to regulate interstate commerce and commerce between a state and a foreign country like Canada or Mexico or whatever. So you have to start using the mark and putting it on goods, either the goods themselves or on the packaging for the goods, and shipping those goods in interstate commerce. Even if your business is here in Springfield and you ship, let's say, a box of food, some type of food stuff, coffee or whatever, to a customer who bought it from you in Hartford, Connecticut, well, that's enough. That's interstate commerce. And with regard to services, let's say you own a restaurant, once you start advertising your restaurant services, and let's say you're based here in Springfield and you do internet advertising or you have a Facebook page, you start advertising these services and you start getting customers coming up from Enfield, Connecticut, or somewhere in Connecticut or Rhode Island or New Hampshire, then your rights in the mark as used on those services, they begin on that day. So what are the rights? Well, it's the right to stop others from using confusingly similar marks in the same goods or services. Again, we're trying to avoid a likelihood of confusion. In other words, I say down here in the fourth bullet point, the first user wins. In other words, the first user of the identical or similar mark on the identical or similar goods or services has priority. In other words, he or she wins. And those common law rights, important to know, they only exist in the geographic area where the mark is used. So if you're basically just selling, let's say you have a restaurant and you only have one location here in Springfield, your geographic area is maybe at best Southern New England and maybe Eastern New York State. So if someone opens a similar type of restaurant with the identical or similar name, let's say in Florida or Texas or Chicago, you're going to have a tough time stopping the user of that mark on its restaurants outside of this geographic area because you only have federal common law rights. So the way around that lies in the second type of federal trademark rights, and those are registration rights. In other words, you've taken steps to apply for and receive a federal trademark registration for the mark as used on goods or services. And now that registration has issued to you and you get these rights. And I'm going to touch on the rights coming up shortly on another slide. But it's important to note that these rights, either common law rights or the registration rights, they theoretically can last forever as long as the mark is still being used properly. And I'll get into more detail what the word properly means, but as long as the mark is still being used on those same goods or services, then the owner of that mark has those rights. They just keep going and going, basically until the mark stops being used on those particular goods and services. One other thing to note is most states afford their own registration rights. So for example, Massachusetts, you want to file for and obtain a Massachusetts state registration, you go to the Secretary of State website. It's pretty quick and easy to do it yourself. It's $50 per class of goods or services, and I'll get into what class means shortly. When you file the application to register the mark with the Mass Secretary of State, and the Mass trademark laws, they mirror the federal trademark laws a lot. But the legal protection in Massachusetts is only good for 5 years as opposed to 10 years for a federal registration. And those Massachusetts state trademark rights for registration in Massachusetts are only good within Massachusetts. Some people who have businesses that are located only in Massachusetts and who don't do any online sales of goods or advertising of services, then it's probably recommended that they go ahead and get just a Massachusetts state registration for their trademark. But if you do online advertising and marketing, which is going to go outside of Massachusetts, particularly all over the country, all over the world, then you really instead you want to focus on your federal trademark rights. So the next slide, here are the benefits of obtaining a U.S. federal registration for your trademark. You get legal presumptive ownership of the mark. So you're the owner. It'd be tough for someone to challenge that assertion that you're not the owner of the mark. And the registration gives constructive notice everywhere of your claim of ownership of the mark. And it gives you the exclusive right to use that mark throughout the United States on the listed goods or services. That's important. Remember, for common law federal rights, you only had the right to use it in your geographic area. But if you get a federal registration, you can use the mark exclusively to yourself all over the United States. And it also gives you the right to use the federal registration symbol, the capital R inside of a closed circle in conjunction with the mark. It gives you the right to sue someone for infringement in the federal district court. And if you sue and you prevail against the defendant, you have the ability to get enhanced damages, money damages, if the defendant is found to be willfully infringing your trademark. And here's an important one, that registration becomes incontestable after 5 years of continuous use of the mark after it's registered, which means that you sue someone, let's say year 7 after the registration issues, that defendant cannot come back and claim that you do not have ownership rights in the mark, you don't have the exclusive right to use the mark nationwide, et cetera, et cetera. So that turns out to be a very powerful right, this right of incontestability. Excuse me. And then the registration also gives the owner the right to record the registration with U.S. Customs and Border Protection to help prevent the importation of infringing goods from outside the U.S. into the U.S. And I'm going to talk about that in a little more detail later. So on next slide, let's talk in the next couple slides but a procedure for selecting a trademark. So you're a startup, you're a new business, or you're an existing business, you're coming out with a new product line or new services, and you want to brand that product line, or for your new business or existing business. So you want to choose a trademark. You want to start off by choosing a trademark. So you may be thinking of using words or designs or combinations of the two, or colors even, or shapes, sounds, scents, smells, whatever. Whatever you're thinking about doing, keep in mind the level of distinctiveness of that mark is very important. And that applies a lot more to words than to the others, but it applies to these other categories of designs, colors, etc. So if possible, choose a mark that's inherently distinctive. In other words, it'll stand out with respect to your goods or services. Now I'm just going to talk about these other bullet points under this first heading of choosing a possible trademark. Now I'm going to go into a couple slides later on that talk about distinctiveness. Then I'll come back to searching for availability for someone to use a mark. But also, don't choose a trademark close to a well-known mark of a company with deep pockets, because they will literally litigate you to the possible death of your company. So for example, McDonald's, if you want to choose a mark that starts with Mick, Mick, whatever, your last name, or Mick something for coffee or anything, or Anheuser-Busch, you want to choose a mark that includes butt in it, you're really asking to get a cease and desist letter or a possible lawsuit. Here's another example. The good folks at Iron Duke Beer Brewery in Ludlow, they started their business about 6 years ago or so. They've put a lot of blood, sweat, and tears into it. Well, about 3 years ago, they got a letter from an attorney representing Duke University, deep pockets in North Carolina. And it was basically cease and desist, stop using Iron Duke, because Duke University has some trademark registrations. They have one in particular for the name Iron Duke's Varsity Clubs, which is a club that sells things, including alcohol and stuff. So there was, I'm not involved in this matter, so what I'm telling you is what I read in the public on masslive.com and in Business West. But Iron Duke, they negotiated with Duke University, and Duke University kind of held the pedal to the metal, and Iron Duke is now forced to change its name, its trademark. I mean, everyone knows it as Iron Duke, and unfortunately they're going to have to change. They're in the process of doing it. I don't know what they're changing to, but we'll see if maybe they're going to keep Iron and get rid of Duke, or just eliminate those two words entirely. I don't know, but they've spent a lot of money developing their brand in the last 6 years, and unfortunately they made a decision to change it. Again, there was no lawsuit. I understand it was filed by Duke University, but if Iron Duke wasn't going to change their name, then it looks like Duke University would have sued them, and then Iron Duke probably would have lost, because there's a likelihood of confusion there between Iron Duke and Duke, Iron Duke's Varsity Clubs, and the respective goods and services. So another issue that I get asked a lot is they'll say, hey, I have a business name or a trade name that I've registered as the name of my LLC or professional corporation with the Massachusetts Secretary of State. Can I use that name, my business name or trade name, as my trademark? And normally the answer to that is no, but if your business name is such that you can and want to use it as a trademark, in other words, as an identifier of goods and services, then yes, you can also claim federal common law rights and try to register, get a federal registration issue. For example, let's say the name of your business is, your LLC is, I don't know, Joe's Best Coffee or something like that. Joe's Best Coffee LLC. And you decide you want to hold out Joe's Best Coffee as your trademark, as your word mark in that, then yes, you could, then in that instance, you want to try to register it as a trademark. But instead, if your business name was, I don't know, 123 Main Street, Springfield LLC, then that's probably not something you want to also use as your trademark. So, all right, before I talk about search for availability use, let me skip ahead here to distinctiveness. I got a couple slides here on that topic. Remember, to be afforded trademark rights, either common law or to obtain a registration, your trademark that you choose must be distinctive in relation to your goods or services. There's two types of distinctiveness. Either a mark that you choose is inherently distinctive. In other words, it identifies the origin of the goods or services once you adopt it, or it's not inherently distinctive because the mark has, let's say it's a word mark, it has a primary meaning as a word to the public. You're trying to adopt a secondary meaning of that mark as your trademark. Well, that acquired distinctiveness takes time to develop rights in the mark through acquired distinctiveness. You may need to provide surveys, public surveys, where the public says that, hey, I recognize that a certain word mark, if I see that, I know they're a provider of, certain food stuff or clothing goods or whatever. You may have to provide samples of ads to prove to the U.S. Patent and Trademark Office or to the courts that the mark that you chose has acquired distinctiveness over time. As a fundamental axiom, the more distinctive the trademark is that you choose, then the stronger the mark will be, and the better it functions as a source identifier and also as a brand protector. In other words, the stronger the mark, the easier it is for you to be successful when you assert your mark against an infringer, either via cease and desist letter or a lawsuit. So the question becomes, how soon does the mark create an association in the minds of the consuming public between that mark and the source of the goods or services? Good marks create this association instantaneously. Bad marks take a while. So just keep in mind distinctiveness when you're choosing a mark. So what is distinctiveness specifically? Here's a slide that's it's common. You see this a lot if you Google distinctiveness of trademarks. It's the spectrum, and it not only applies to distinctiveness but also to the protection of marks. In other words, how easy will it be for you to prevail if you assert your mark against an infringer? And it's also indicative of the strength of the mark. So we'll start at the top here with fanciful terms. They're either made up or coined words. They have no other meaning to the public. For example, Exxon, Rolex, Kodak, Pepsi, Chlor. These are all made up words. They had no other meaning prior to them being made up by the brand owner. These marks, I highlighted the statement inherently distinctive in green because they're good to go. If you pick a mark that's made up, you've probably picked the strongest mark you could for your goods or services. And it's inherently distinctive, which means you could assert it against someone. If someone was infringing shortly after you adopted it, you probably could send them a cease and desist letter and prevail. So the next category down on the spectrum is an arbitrary mark, which is a common word that's being used in other than its normal context. So Apple for computers. You know, we all know Apple as a fruit, but prior to Apple Computer Company coming to existence, Apple wasn't used on computers. Same thing for Camel for cigarettes, used in its other than a normal context. These arbitrary words are also inherently distinctive. Then dropping down on the spectrum are what are called suggestive marks, which are marks, trademarks that tend to suggest or do suggest a characteristic or quality of the goods or services. But they require imagination or thought for someone to connect the mark with the goods or services. So those are also inherently distinctive. An example of that is Netflix, because Netflix tends to suggest a characteristic of the goods or services, the streaming movies or television services, but you know, it's takes a little imagination to do so. So those are still inherently distinctive. The next one down are called is a descriptive category. But now the line of demarcation between suggestive and descriptive is starting to get blurred a little bit. But descriptive marks describe a feature, a quality, a function, an ingredient of goods or services. So those marks are not inherently distinctive. To qualify as a trademark, you're going to have to use the mark a lot over time and to develop secondary meaning in those marks and to obtain a federal trademark registration. So an example is Sharp for televisions. Also, laudatory terms fall under the descriptive category, geographic designation, and surnames. So again, there's some blurring between suggestive and descriptive. If at all possible, you're better off up in the fanciful and arbitrary categories instead of suggestive or descriptive. Then the last or bottom category are generic terms, which cannot ever function as a trademark. I highlighted that in red because it's the common name for the goods or services. So let's go back.
Rick, there's a question in the chat.
Okay.
So if 10, well, there's two questions. If 10 times annual sales is a method of determining value by a company, then is 800 million cheap? And then the next question.
I'm sorry, what was the first question?
Please stop. If 10 times annual sales is a method of determining value to a company, then is 800 million is cheap?
Yeah, obviously McCormick did due diligence. You know, they looked at all the hard assets and the intangible assets of Cholula, you know, including the goodwill, the brand equity, the trade secrets, and they placed a value on it. And also they were thinking about, okay, how are we, you know, how soon can we grow this brand to recoup some of our investment? And I think taking into account these various factors, they decided 800 million or roughly 10 times and current annual sales is what they were going to pay. So I don't think it's just, I don't think they just said, oh, well, we're, you know, we only pay at most 10 times earnings. I mean, I think, you know, a little more number crunching went into it besides just that.
And then the next question is, what is the cost of a federal trademark, and if there are renewal fees, and does a federal protect against international infringement like a patent? I'm not sure if you're going to be.
Yeah, I am. I'm actually going to talk about that coming up very shortly. There are filing fees per class of goods or services. They're either $225 or $275 per class, and I'll get into what a class is. The United States federal trademark registration is only enforceable in the United States. So if you want to get protection in Canada, you know, if you're going to be doing business in Canada or Europe somewhere, whatever, it's suggested to get trademark protection there. But I have a whole slide, I think 2 slides coming up on U.S. federal trademark registration, how to do it, how much it costs, and also how to file for and obtain trademarks outside the US. Okay, so after you've chosen a mark, keeping in mind level of distinctiveness and these other factors, you need to search to see if it's available for you to use on the identical or similar goods or services. So a couple of ways to do. You can do it yourself, online search. If you chose a word mark, I suggest you go to the U.S. Patent and Trademark Office website. The first one there, uspto.gov. It's good for word searching, and it'll come back and tell you which a mark that's identical or similar to it, if it already has a trademark registration, and if that registration is still in force or it's lapsed for whatever reason, or if someone has filed an application to register that mark, and it'll tell you the goods or services that are used with that mark. But the uspto.gov, it's not very good for searching to see if you have a proposed image or design or logo. It's very difficult to do it. They don't have the capability of plugging in like JPEG files and then looking. You have to dissect the logo that you're trying to search for into various components and fit it under a complicated 6-digit numbering scheme, what they call an online search code. So when I look for, when I'm trying to determine if a client of mine has a logo or design that they want to register, I go to these other websites. I either use yandex.com or tineye.com or even Google Images. There you can just upload a JPEG or a TIFF or a GIF file. They don't allow you to use a PDF, but you put in a JPEG, and literally within seconds it comes back and it gives you a lengthy list, not a lit, but a lengthy on the screen of all these similar images as they're used, not only as trademarks, but that they're used in any commercial setting anywhere in the world. So it's a good, quick, easy way of determining whether a mark could be possible for you to use. Or if you don't want to do it yourself, you can hire an attorney, or there's search firms. There's a lot of online search firms now. They may charge anywhere from $100 to $500 to do a search for you, these search firms. You don't need an attorney to work with them. You can just contact them and send them the image or an image of the logo or design you're trying to register or you want to adopt and use, and they'll search it for you and see if it's available. So after you've chosen a mark, you've searched it, and you've said, okay, I think I want to use this mark on my goods or services. Now you have to clear the mark. You've searched it, but you're getting results back either online or you're getting results from an attorney or whatever. You got to decide, could there be a likelihood of confusion? In other words, if you adopted a certain mark on similar goods or services, would there be a likelihood of confusion? And if you hire an attorney to do that, he or she will give you their opinion of what they think. But if there could be a likelihood of confusion, usually, if someone's already using that mark, that someone is the first user on those goods or services, then you just pick another mark and go through the process again. But let's say you find a mark that you like, you've searched it, you've cleared it. Now you want to adopt and use the mark. So now you're starting to use it on your products, on your services. So the proper way to use it as an adjective before the generic descriptor or noun for the goods or services. In other words, Coca-Cola soft drinks, Monsoon Roastery coffees, Never Cattywampus building remodeling services. So remember I said earlier, once you start using the mark, you have common law federal trademark rights. So that means you can use the common law symbol, the TM, capital T, capital M. You generally use it as a superscript after the trademark on all your marketing materials, including your website. Or if you filed for and you receive a federal trademark registration from the United States Patent and Trademark Office, you can stop using the TM and you can switch over to the capital R within a circle, the federal registration symbol. Another thing to do is advisable is, let's say you're on your website or your brochures or whatever, it's sometimes advisable to set out the mark in a different font size or style. So let's say Never Cattywampus, maybe make it a bigger font or a different style than the rest of the text in that piece of marketing material. All right, so we talked about distinctiveness. One quick thing, some people have asked me, gee, I saw the same trademark used on totally different goods or services. Is that okay? Well, yeah, it could be. In other words, the same trademark for use with different goods or services, having different owners, can legally and peacefully coexist. Why? Basically because there's no likelihood of confusion that could occur in the relevant marketplaces of these various goods. For example, and it's probably the best known example, is Cadillac. We all know Cadillac is General Motors. They make cars, SUVs, whatever. But Cadillac there are also federal trademark registrations for dog food, hotel services, razors, fruits and vegetables. All of these are different owners and they're all different than General Motors. And that's allowable because there's no likelihood of consumer confusion in the marketplaces for these different goods. So, but as I say on the bottom here, it may not be wise to choose the identical or similar mark for your goods or services, even though you think your goods or services are or will be different than the existing mark owner. There's this concept called natural zone of expansion, where the mark owner could legally expand into the same area of goods or services that you're thinking about entering. So for example, let's say a mark owner owns the mark Cadillac for shirts. Let's say Cadillac is not used for cars or the other ones I listed there, but let's say somebody has a registration for shirts and you decide you want to get into making socks and selling them. Well, socks and shirts are both items of clothing, so it's most likely that the first user of the mark Cadillac on shirts has the right to expand into socks because it's the same type of goods or services. In other words, articles of clothing. So in my experience, choosing the same or identical mark that someone's already using is probably not a good idea. All right, so let's talk about federal trademark registrations. You've adopted a mark, now you want to obtain a registration for it. There's two filing bases that you can use when you're filing the application. The first one is what is called actual use, which means you've already made actual use on the goods or services and provided those goods in interstate commerce or services. In other words, you've advertised your restaurant services on your website. If you haven't made actual use of the mark yet, you can file under what's called an intent to use basis, which means you have a future bona fide intent to use the mark on the goods in interstate commerce. And it can't merely be to reserve a right in the mark. In other words, you have to have a bona fide intent to use the mark. In other words, you can't file merely to reserve a right. That's what's called squatting. A good example of that is the Washington Redskins football team. They changed their name prior to this season. They call it the Washington Football Club, but they started thinking about changing their name about 5 or 6 years ago. due to social pressures. Well, this one enterprising gentleman in Northern Virginia, he decided to start filing a bunch of applications to register different variations of trademarks for use on. Now he doesn't have a football team of any sort, but he was filing for registration. And he's received some federal registration for things like clothing and sports items that would be associated with the running of a football team. So he's got about 30 total applications and registrations for things like Washington Red Hawks, Washington Red Wolves, Washington Monuments. So when the Washington Redskins finally decided to change their name, he said, well, I'll sell you my trademarks. And the Washington Redskins say, no, we're not going to do that. So that's why they're still trying to think of what's a name to call themselves. So they played this whole season under the moniker Washington Football Team while they're trying to sort through these trademark issues. All right, so if you file an intent to use application, again, you're doing it because you have an intent to use. But before you get a registration issued to you, you have to make actual use of the mark on the goods and services in interstate commerce. So regardless of what basis you file under, intent to use or actual use, you should keep track of the dates of first use of the mark in both interstate and intrastate commerce, because you're going to have to submit this information to the U.S. Patent and Trademark Office as part of your application. And also keep copies of specimens of use of the mark on the goods or services, because you're going to have to submit that as well to the Patent and Trademark Office. In other words, for goods, normally trademarks are used on product packaging or labels or tags or something like that. And for services, like I said, it's usually advertising. Or let's say your restaurant or whatever you're providing. And that could be screenshots of your website. So keep track of that. Now to file, you can do it yourself or you can hire an attorney. You do it yourself or either way, it's right now the USPTO only allows electronic filing through what they call their EFS web system or electronic filing system. There used to be a paper filing option for years and years and years, but that was eliminated earlier this year. So the current filing fee is either $225 or $275 per class of goods or services. But this is increasing to $250, $350 on January 2nd of next year, so less than a month. The trademark fees have not been increased in about 3 years. The federal government just increased the patent fees earlier this year, so now they're increasing the trademark fees. And when you file the application, you can pay by a credit card. It's pretty easy. So let's talk more about class of goods or services in the 225, 275. Pretty much every trademark office of every country follows this international classification manual, or it's called the NICE, N-I-C-E classification, which was hammered out in Nice, France years and years and years ago. But there are 45 different classes of goods or services in this manual. The first 34 classes pertain to goods. The remaining 11 classes pertain to services. And in each of those classes of goods or services, there's all kinds of labels for coffee, coffee beans, roasted coffee beans, green coffee beans. It just goes on and on and on. So what you're trying to do is you want to select, if you can, or fit the type of goods or services that you want to get registered for into one of these classes of goods or services, so you pay the lower 225 fee per class. The reason that is if you pick what's called a CAN descriptor for your particular goods or services, then you're reducing the amount of work that the trademark examiner has to do, if you didn't pick one of those canned listings of goods or services. So not always can you pick one of those canned goods or services, primarily because it's not going to be accurate for the goods or services that you use and you want to register for. So if you can't fit your goods or services into a canned listing, you make up your own listing that's accurate, but you pay the higher $275 fee per class. Now, if you only sell one kind of product and you don't provide any associated services with it, then you're probably going to end up in just one class. So you're only going to pay $225. But let's say you sell coffee, but you also sell items associated with it, like shirts, mugs, other things. Well, those shirts and mugs are going to take you into other classes. So if you want to get a trademark registration for your mark, as you use them on coffee mugs and shirts and hats, whatever, you're going to end up paying a multiple of $225 because you maybe end up in 3 or 4 different classes. And if you also provide services, let's say you have a retail sales location where you sell coffee, brewed coffee to customers, then you're going to have to pick one of those 11 services classes. So, you know, the total cost to file could easily be 3 times $225 or 4 times $225, whatever. So once you file the application, the best case, if there are no objections to it, it'll be about 9 months between the date you file it and the day you get your registration to issue. And then again, once the registration issues, you have all those more powerful rights under federal laws. But it's going to take more than 9 months if the application was rejected by the examiner at the USPTO for some reason, or if the examiner said, okay, I want to issue a registration. Under federal law, they still have to give anyone anywhere in the world a chance. There's a 30-day window where anyone could oppose the PTO giving you a registration, but it has to be on a good faith basis that anyone feels they could be damaged if you were to get a registration. So that usually comes into play when someone already has common law trademark rights that you as a trademark owner weren't aware of when you adopted the mark and you filed for the registration. And also the examiner at the PTO was not aware of it when he or she decided to allow a registration issue. But that's the exception and not the norm. And also it could take longer than 9 months if you file the application initially as an intent to use, because then even if the examiner says, okay, I'll give you a registration, and 2, no one opposes the registration, you still have to make use of the goods or services with the mark in interstate commerce before you can get a registration issued. So that could take, you have from the day the day they tell you, the PTO tells you you'll get a registration, if you make use of the mark, you have a 3-year period within which to make use of the mark. And usually that's plenty of time for you to do so to then get the registration issue. All right. So now you want to think about filing for registration outside the US. Why? Because trademark rights are territorial. They're by countries. Remember I said earlier, a US registration is only good and enforceable in the United States, its territories and possessions. Federal common law rights under US federal law are only good in the United States. And there's no single quote unquote international trademark registration that's enforceable throughout the world. So now you got to think about, I'm sorry.
No, that's okay. I'm sorry. Before we move on to the outside of the US, there's a question in the chat that Elizabeth said she received a trademark from the patent office this year. The logo is a 2-color design for the description. And she just described the logo using black and white. Would she be able to change the color on different shirts? And also, what can she do if she uses the classification for shirts, but also wants to offer decals or something other than apparel?
Well, the for the latter question, if the registration only covers shirts, then it does not cover goods that aren't related to shirts, like decals or, you know, other things, you know, consumer product, cars, whatever. Then if the goods that she wants to use it on are sufficiently different than shirts, then she'd have to file another application to register for those additional other classes of goods or services. And I'm sorry, what was the first question again?
The first question I think was about the logo was described as a two-color design for the
Right.
description, and whether or not she'd be able to change the color.
Well, I guess did the registration say what colors those two colors were? Because if so, in other words, the registration says it's a color, it's a logo that embodies both a blue and a yellow, let's say, colors. Then ostensibly that registration only covers blue and yellow. There's other factors as well, as you know, in other words, is that logo very distinct such that, you know, no one else would really use it without infringing, or is the art crowded? In other words, are there other similar logos that are being used? You know, I'd have to see what she'd have to tell us, you know, what's the language of the registration. Does it say specific colors, or does it just say two colors? Because I think if it says just two colors without naming which colors they are, she can probably then swap around the colors as long as she limits it to two different colors. If she starts using just one color or four colors, then I think, you know, there may be some issues there as to.
Yeah, she said in the chat that it says black and white.
Okay. Well, if she says black and white, then it probably doesn't cover colors other than black and white. You know, may not cover green and red or something like that, because usually a registration, it's, you know, what the language is in the registration or what, you know, it governs it. So that's why you kind of want, if possible, stay away from specifying colors when you're applying for trademarks. Same thing where you want to stay away from specifying certain font styles or whatever. You want to file instead for what's called a standard character mark, which if you get a registration issue on that, then you have the ability to stop people from using all different font styles and sizes. It's a stronger registration that way. So I can speak with her, you know, offline. I'll have my contact information at the end, and I can talk to her afterwards.
Thank you.
Okay.
And then there's just one more question in the chat, and I think that it's kind of along this lines, but if you advertise your trademark in a local community newspaper that borders another state and is distributed in the adjoining state, does that constitute first use and actual use for its iterate purposes?
Well, for services, yes. For goods, no. Advertising is not sufficient use of a mark for goods. Instead, you have to use the mark on the product itself or its packaging. So it's usually a label or a tag that goes with the product as it goes across state lines to someone, like I said, in Enfield or whatever. But if it's services, you know, let's say it's the Reminder newspaper, which is popular here. Let's say, again, you have a restaurant here in Springfield, let's say, and the Reminder goes to people. I know it goes to people in Long Meadow. I don't know. It may even go to people in Enfield. They may have a version that goes to people in Enfield and Summers. Well, if so, then that advertising of your restaurant services is sufficient to qualify as a usage of the mark on those services. Okay. Any other questions?
Not right yet.
Okay. All right. So let's talk about filing for registration outside the US. So again, trademark rights are territorial, and unfortunately, there's no single registration enforceable throughout the world. So you got to think about where do you want to file to obtain registered trademark rights in? And the rights of registration are fairly similar as compared to US registration rights in other developed countries in Europe, China, Japan, etc. But you should think about these factors here. You consider what countries you do business in. In other words, where do you have an online presence? I mean, you could be a small shop selling candles located in Chicopee, but you have customers in Canada, you have people buying your candles in China, India. So you may want to think about, should I get trademark protection in India to stop people from knocking off my trademarks in India? Also look at, where are your current customer markets? And where are you thinking about expanding your markets to? What countries? Other things to think about, where are your manufacturers located? You may sell product, you may put the finishing touches on products that are made here in Springfield, but maybe most of that product is made somewhere else in a different country. And it gets shipped here and you assemble it all in Springfield in your factory, and then you ship it out from Springfield to your customers. So where are your manufacturers? Where are your suppliers? Where are your distributors? Maybe you have a network of distributors in Asia, Europe, Africa, South America, Central America, wherever. Those are all places to think about, where do you want to get protection? And also, where are your competitors located? Maybe you don't have any competitors, that's great, but maybe you do, and you have some very fierce competitors that, there's not a whole lot of difference. Maybe you're the market leader and, you have your competitors nipping at your heels. So you may want to get trademark protection there. Also, the thing to consider are the fees. Most countries adhere to the international classification of goods and services. So, as we saw, it's either 225 or 275 in the US per class of goods or services. Same thing in foreign countries. Then there's other filing fees. There's attorney fees, because a lot of these you have to hire an attorney in Europe or wherever. Also, what's your ability to enforce your rights? A lot of countries, they don't like Americans. They're not going to help you enforce your rights in their country. What would the cost be if you had to hire lawyers and go, open up a full-scale litigation war against someone who's knocking off your trademarks? All right, here's some other things to consider. There's a thing called the Paris Convention that's adhered to by 177 countries. It's a worldwide agreement, which says that if you first file an application to get a trademark registration in the United States, if you file outside the United States in various countries within 6 months of your first filed US date, you'll get the benefit of that earlier US filing date. That's important because the United States, as I've said, it's a first to use the mark country, whereas most other countries, it's not first to use, it's first to file. So it's a race to the trademark office in those countries. So there are a lot of countries where they monitor filings in the United States, they monitor businesses that are springing up. And if they see a new business that comes online with a new trademark, and they feel that that company will eventually get to their country at some point, they're going to file trademark registration in their country. It's first to file. So they'll get a registration issue, or they'll at least have one pending. And then if you decide to go into that country, they're going to hold you up for ransom if you want to use your mark in their country. That's kind of cutthroat, but that's the way it is. There are a couple things to make it a little bit easier. In European Union countries, which are about 27 countries now, there's a thing called a community trademark. You file one application with the European Union Intellectual Property Office. And if it passes all the hurdles, you get a single registration that's enforceable throughout the entire European Union. And you only need to make use of the mark in one European country, not all 27. Remember, in the United States, to get a registration issue, you have to make use of the mark in the United States to get a registration. In the European Union, you just need to make use of the mark in one country, not 5 or 10 or all 27, just one. The other vehicle is called the Madrid Protocol. It's another international treaty. You file one international application in English language with the US Patent and Trademark Office. They'll then forward it on to the World Intellectual Property Organization, or WIPO, in Europe. This you can do yourself, no attorney required to file. It's about $2,000 or so, depending again on how many classes. But that one class is usually about $2,000, 2,000 US dollars to file. And it's applicable in 90 countries, the filing. But then the difference between a community trademark in EU countries and this Madrid Protocol is you still need to obtain a registration for, if you're using Madrid Protocol, in each country that you're interested in. So, you know, there's no 1 in 27 countries like the community trademark. You have to then go into, you know, how many of those 90 plus countries you want to go in, and you're probably going to have to hire an attorney at that point. So it's a way to consider going if you want to file outside the US and file outside the European Union. You may want to look to the Madrid Protocol to do that. All right, so your US registration is issued. Congratulations. You can now start using the R in the circle symbol instead of TM. The registration lasts for 10 years. But 5 years after the registration, if you're still using the mark on those same goods or services listed in the registration, you file what I just call still in use documents. You file what's called a declaration of use, and you file this other affidavit, which, remember I said earlier, if you keep using the mark for at least 5 years after registration, your registration becomes legally incontestable. So you file this, what's called a Rule 15 affidavit. You file that after 5 years. And then after 10 years, if you're still using the mark, you file these documents, the still in use documents, and the registration will reissue to you. It doesn't go through this examination process like it did initially. So this way is you can perpetuate your federal trademark rights as long as you keep using the mark. If you're not using the mark anymore, then your registration is going to lapse, and then someone else can pick it up for those same goods or services later on. All right. So also you have your federal rights of registration, or even just common law rights. What you should be doing, you should police your trademarks constantly. Why? You want to prevent lost sales, to infringers. You want to prevent the dilution of the value of your marks. In other words, the brand equity that I spoke about earlier and the goodwill to your company, and damage to reputation. Someone's flooding the market with cheap knockoff goods. That's going to be a damage to your hard-earned reputation that you built up in selling, your goods of high quality. So how do you do this? Well, you set up a watch list to monitor for infringing uses. Simple to do yourself. Just keep searching the internet. Put your logo into yandex.com or TinEye. Search the internet for your word mark or phrases or slogans and see what pops out. Or you could use a third party. One company that does this for a service called CPA Global. They'll do the work for you. So let's say you find someone who's infringing. What do? Well, you should at least send them a cease and desist letter. Tell them, hey, I have rights in the mark. I see you're using it on similar goods and services. There could be a likelihood of confusion between us, you and me, therefore I ask you to stop. If they don't want to stop, you file a lawsuit in federal court, US federal court, for both trademark infringement, and there's another powerful thing called unfair competition, which opens the door under this new different cause of action to get you damages as well if you prevail. What else can you do? Well, you have a US trademark registry, you record it with the US Custom and Border Protection to help prevent importation of infringing foreign goods. CBP can detain, seize, forfeit, destroy goods. You need a valid US trademark registration. You have to record it with US CBP, but they have a good website to do so. They charge $190 per class of goods or per goods to record the registration with them. And if you renew your registration, your US trademark registry, you have to re-record or renew the recording with CBP. And CBP likes trademark owners to help educate their personnel. Some of the things they want you to do is provide them with product ID guides, help them identify your products when they come in on shipping containers from overseas, let's say. If you want, you can give them training at ports of entry into the United States. You can even give them live webinars about your product. You can also report suspected infringements or any violations of your trademarks to them. Other things, Amazon started a brand registry about 3 years ago. You need a valid US trademark registration. And they do it not only in US, but other countries like Canada, some European countries as well. You do it online with Amazon. It helps Amazon to take down these infringers, these infringing sellers or sellers of infringing goods rather. And then Amazon and eBay both have what are called takedown procedures. You don't need valid trademark registrations to do that. You just have to assert rights in the marks, and they'll shut down websites that are selling infringing goods. We're almost out of time here, I think, right?
Yeah, it's been great.
Can I just finish up 1 minute?
Yeah, that sounds good.
Okay. I said before, proper use as of a trademark is an adjective before the generic term or noun for the goods. The bad news is if you don't use the mark properly, over time it loses its ability to identify and distinguishes, and then it becomes a generic descriptor of the net thing itself. So this is actually right off. Unilever is the company that makes popsicles, creamsicles. This is right off their website. They're educating the public how to use their trademarks. I encourage you to take a look at it, because if you have trademarks or you're going to get trademarks, this is the kind of public education you need to be doing. And if you don't do it, these are all examples of marks that have lost their ability to distinguish and have become the generic name for the goods. Linoleum. Well, it used to be linoleum brand floor covering, ping pong brand table tennis, and then others that are getting closed, Zamboni, rollerblade. They're still trademarks, but everybody says, hey, I'm going to go buy some rollerblades, or I'm going to go rollerblading. Well, that's not the way to use it. Rollerblade has to be used as an adjective in front of inline skates. So, and that was it. I had a quick summary of what I talked about. Thanks everybody for participating. Here's my contact info, my LinkedIn profile. I'm developing a new website for myself, hopefully early next year. And this isn't valid anymore. We've decided to push this out into probably January, these office hours. But if anyone on this workshop has questions or whatever, they want to talk to me in the future, reach out to me via email or my cell, or hook up with me on LinkedIn. Thank you very much.
And if you're interested in the future in these office hours, you can feel free to reach out to me as well, or Rick, so that we can make sure that we send you the information for when the office hours are going to be available in January. Great. Rick, thank you so much. This was very informative. I really appreciate you.
Thank you, Hope. I appreciate it as well. Thank you, everybody, for participating.